You've worked as a paralegal for a long time. What is one of the most challenging cases that you've come across and what happened?
A landlord who went to the Landlord Tenant board to evict for his family use from an apartment that was getting too cramped for his growing family into this perfect place because it was a building he owned where he worked downstairs and he had the whole upstairs floor for his growing family. So he went to the Landlord Tenant board unrepresented and he lost.
Coming back to the international students, have you heard of any horror stories?
Sure. I go online every day Googling for landlord-tenant issues. And when you have an illegal basement apartment, even with one illegal basement apartment, you've become partners in crime with your tenants because the tenant then holds tremendous power over you.
At this point of time, the Landlord Tenant Board matters. The hearings are taking over 200 days. Why do you think there's such a backlog?
Well, certainly COVID, it closed from March 20th till August. It closed for 5 months, so they've never got through that backlog.
There have been a lot of short-term rentals, Airbnbs. So how does it change the landlord-tenant dynamics?
Short-term rentals are complicated because different cities have their own bylaws in some cases. You look at Toronto's, for instance. I've got a figure that 2/3 of the Airbnbs in the city of Toronto are illegal. I love Airbnbs if I go to Rome. I hate Airbnbs in Toronto.
How can a landlord pre-screen a tenant?
It's a controversial topic because...
Hi, I'm Manish Kapoor tuning in from Canada, and I'm really glad you're here. This is where we sit down with some amazing minds, leaders, creators, and change makers to talk about the things that matter. Every episode is a chance to learn something new, get inspired, or just hear a fresh take. So let's get into it.
Today on the Kapoor podcast, I'm joined by Harry Fine, a distinguished paralegal, former adjudicator at the Landlord and Tenant Board, and a widely respected educator in Ontario's legal community. With decades of experience navigating landlord-tenant disputes, legislative reform, and legal education, Harry has become one of the most trusted voices in the field. In this episode, we'll be discussing the current state of landlord-tenant matters in the Greater Toronto Area, from legal backlogs to tenant rights and landlord challenges, whether it's breaking down complex housing laws or advocating for fairness on both sides of the rental equation. Harry brings sharp insights, real-world experience, and a deep passion for justice. Let's dive in. All right, Harry, welcome to the show. We'll get started with some fun questions and then we'll get down to the real stuff.
I hope they're fun.
Yeah. So what do you prefer, texting or calling?
Oh, that's an easy one, texting. Calling, people want to take your time. They'll tell you it's going to be just 1 second, 1 minute, and it's not. So texting, unless it's, I'm engrossed in the topic and I have to deal with it, then I'll get on the phone. But texting makes life so simple and so efficient.
And do you prefer to receive texts or calls?
Text to start it. It lets me organize things. Yeah. I'm in control.
Perfect. What is your favorite sport?
Favorite sport absolutely is golf. I'm not very good. It's a tough game. I didn't take it up till late in life, but I love the outdoors. I love to walk, and I play with my wife as well, and so it's great.
Perfect. And what do you prefer to chill? Reading a book or watching a movie?
Absolutely reading. I'm a voracious reader of all sorts of books, science fiction, historical fiction. I love to read.
Great. So, Harry, now we'll get down to the real stuff. Some questions that I'll ask you about the current situation of landlord-tenant board matters in Ontario. You've worn many hats. You've been an adjudicator, you've been a teacher, and you've been a paralegal. How did those transitions happen?
Well, actually, I started in a family business. My father in 1959 started Bowlerama, the largest chain of bowling centers in Canada. But we sold it because the business was changing and evolving. So I had a friend who was at the time the Attorney General of Ontario. And he said, Harry, you'd be great at this. And I got an appointment at the LTB, studied hard, and loved every single day of it. But public appointments to various boards and agencies and tribunals, they're term limited. And they're particularly term limited when governments change. And in 2003, the government did change. And I loved every minute of being at the board. And I thought, why don't I try this and open my own firm, particularly with emphasis on landlord tenant, but also some small
At the
claims.
time, you were an adjudicator?
Yes, so I left the board.
How many years did you do that?
I was there for 3.5 years.
Okay.
And I left the board and started my own firm. It was very easy for me. It was almost like cheating because people don't leave their paralegals easily, but I was everybody's second choice. If they weren't happy, let's try that Harry Fine guy. He was a former adjudicator and he was good. I appeared before him several times. I really liked him. So it was easy to build up the business. At first, you're in business with small landlords, and that's more challenging because they need more hand-holding. They're not as sophisticated. They're not repeat clients, so from a business perspective, it's not as good. But then you get what you really want is the institutional landlords, repeat, repeat, repeat. And funny how I got into teaching. A friend of mine who is a lawyer, and he passed away. His name is Peter Libman, and he taught at Humber College, and he contacted me one day and said, "We need somebody because somebody's pregnant. Could you do some teaching just on Tuesdays?" So I started teaching part-time at Humber, and I loved it. And I started teaching 2 days a week there. It was challenging because I had to coordinate scheduling of my hearings with the Humber stuff, but I loved the Humber stuff. And I taught
So what
paralegals.
did you taught paralegals?
Yeah, I taught aspiring paralegals,
Okay.
administrative law, landlord tenant, obviously, small claims, whole Canadian legal system, all sorts of topics. And I enjoyed it very much.
Okay. And are you still teaching there?
I don't. I left because, and this is a little political and controversial, but I left because teaching got different. And the institutions got different. And it was all about people looking to perhaps get second chances. I found that you're always at odds with the college disability support people looking for accommodations that I didn't feel were perhaps appropriate. And it just became too much of that. And I thought, I'm not having fun anymore, so I stopped doing that. And still do a lot of teaching, but I teach to real estate boards, a lot of real estate brokerages, a couple of institutional landlords who want training. And I have a wonderful series, the best series of videos with accompanying materials online. And every day landlords go there and purchase a package on evicting for tenant conduct, evicting for personal use, evicting for rent arrears. One of the packages, and the most popular, and one that every landlord should purchase. I have 3 that are bundled together called the Landlord Essentials 3-pack. And it starts with starting a tenancy, rights and obligations, rent control. Probably for the 3 of them, about 5 hours of video with probably 100 documents between them, templates, samples, forms.
What's the
completed.
cost for it right now?
The individual modules, and there's 10 of them, are $99 plus HST. The Landlord Essentials 3-pack is $249, and it's a small investment and a great investment that will keep you out of trouble. And I'm always keeping those up to date because the law is changing. In fact, earlier this week, I redid post-tenancy claims because I felt the old one was getting too old, and so many things have changed, both at the LTB and then for the enforcement side at small claims court, with respect to how we file, how we appear at the board, because everybody's internet-centric, everybody's gone digital.
Yes.
So I didn't feel it was fair to have the old content, so I redid it.
Okay,
just
perfect.
this week.
And you're still practicing as a paralegal?
No, I'm not taking any clients going to the board anymore. I'm sort of semi-retired.
Okay.
People call me still all the time, and they beg me. I had a guy call me this week. He said, "I'll pay you anything. I want you. I'll pay you $15,000. Take my case." I said, "No." But I refer to good people. I refer only to good people. I don't take referral fees. I refer to good people because I want to help those good paralegals, and I want to help a person who I'm referring to those good paralegals. And I get a lot of joy out of making sure I'm doing good things for people. It's fun.
That's great. Now, Harry, you won the William J. Simpson Distinguished Paralegal
at
Award.
the Law Society, yes.
Yeah, so I think only 6-7 people have won that.
I think by now there's probably 8 or 9 because every year there's
Still
more.
not many. So how did it come along? What were your feelings when you received it?
You're nominated by fellow paralegals, so it was an honor to be nominated. I was always a leader in the paralegal community. I was on the boards of the Paralegal Society of Ontario and the Ontario Paralegal Association, and I taught paralegals. I mentored a lot. I was on government relations committees. I did a lot for the community, and I was recognized for doing that. I was also, it's hard to say, it sounds boastful, but I was sort of the go-to on residential tenancy law in Ontario. And I had a lot of respect from the bench and from the Law Society. I did some courses for the Law Society. And so it all came together, and I received the award, and I was very honored to get that.
That's amazing. Which year was it?
It's probably around 2015 now.
Okay, perfect. So Harry, now one of the things, you've worked as a paralegal for a long time. What is one of the most challenging cases that you've come across, and what happened?
One of the most interesting cases, and certainly challenging, arose out of a landlord who went to the Landlord Tenant Board to evict for his family use from an apartment that was getting too cramped for his growing family into this perfect place, because it was a building he owned where he worked downstairs and he had the whole upstairs floor for his growing family. So he went to the Landlord Tenant Board unrepresented. The tenant was there represented by one of the community legal aid clinics, and he lost. And it was devastating for him. It took a year, and the board, for a number of reasons, felt the application should not succeed. And he found me, and I filed a review. And as you know, it's much harder to pick up the case, pick up the file on review, because first you have to win the review or the appeal before you have it reheard. The legal clinic was there on the review. I won the review.
Yeah.
We heard the matter fresh, de novo. The legal clinic was there hearing it fresh. I won on the de novo hearing. Just before the sheriff enforcement, the clinic lawyer called me and said, "We're filing a divisional court appeal today. It would be bad faith if you evicted." I agreed. Went to divisional court. The matter, or the appeal, was so without merit that the lawyer who I referred the matter to didn't even have to rise and give submissions to defend their appeal, and their appeal was dismissed, and we contacted the sheriff again and scheduled a date, and then I got a call from the legal clinic that they were seeking leave to go to the Court of Appeal. Anyways, at the end of the day, we were successful all the way through, including the Court of Appeal. But the sad thing was, I mean, my client spent a lot of money on all these steps going up. And at the end of the day, he didn't even move in because life had changed over 3.5 years so dramatically. And it was maybe a good example of everything that's wrong with the LTB, that should happen.
So he did not eventually.
No.
But he got the decision in his favor.
Yeah, and then he didn't move out because life had changed, and then the tenant tried to sue him again, saying, "See, you didn't move in."
Yeah.
It's just crazy. That went nowhere, but
I can imagine.
Very sad.
Okay. So say a landlord signs a lease agreement with the tenant. It's a 1-year lease agreement. What happens after the first year?
Well, in Ontario, when you sign a lease, you don't have to have lease term, but most people and most realtors start off the tenancy with a 1-year term. And in Ontario, the tenancy becomes month to month after the year is over. By operation of law, nobody has to do anything after the term is over. It's just you continue to pay your rent. And lease term is one of the most misunderstood concepts by realtors, by small landlords, because they don't understand that a tenant has the right to stay there forever unless the tenancy is terminated by the board, or unless they decide to move, or unless they die, or unless they give notice or by agreement, or are evicted by the board. The tenant has a right to stay. So landlords, after the year is over, they ask the tenant, "Oh, are you staying?
Yeah.
Are you leaving?" And the tenant says, "Why would I be leaving? I didn't give notice." And meanwhile, the landlord hasn't given a notice of rent increase at least 90 days prior to that. So the landlord says, "Oh, you have to start paying the new rent." Well, no, I don't. I haven't been served with my notice of rent increase. And also not understanding term and the whole first and last, the deposit. The landlord, because they don't understand the difference between tenancy, which is the big thing, and term, they apply the last month's rent deposit to the last month of the term rather than the last month of the tenancy. So now there's confusion. But in Ontario, when the year is up or the term is up, tenant stays. And in fact, term is not good for landlords. I just did a short on YouTube, and I think I called it Term Sucks for Landlords. And it's true, because the benefits are all to the tenant. The landlord can't file an application to evict for any of the no-fault grounds, landlord, family moving in, purchaser, family moving in, demolition, extensive renovation, a change of use to non-residential. Those are all off the table during lease term. And what does the landlord get for lease term? He gets some comfort that the tenant may stay for the term of the term. And if the tenant doesn't stay and decides, I've got a job in Vancouver and it's only 6 months out, what are you going to do? You're going to sue him from Vancouver? You're going to enforce in Vancouver?
Yeah.
And besides, the landlord has an obligation, once they find out the tenant's going to be in breach, the landlord has an obligation to try to re-rent. And if the tenant says, I'm going to Vancouver in 2 months, the landlord has lots of time to re-rent and shouldn't suffer a loss. So term does nothing for landlords, except sometimes unexpectedly it traps them.
So just to clarify, if now the landlord and tenant are still, or rather the tenant is still living in that house for now 5 years, he does not have to do a new lease agreement.
Oh, you never would do a new lease agreement. Some landlords say, well, I'm going to do a new lease and I'm going to raise the rent by having a new rent amount in the lease. Even if they gave the lease 90 days prior, which is part of the 5 rules for raising the rent, that doesn't raise the rent. The only thing that raises the rent is the landlord serving the tenant with a landlord tenant board form at least 90 days prior, served properly, effective the first day of a rental period, and assuming the unit is covered by the provincial guideline, not more than the guideline.
I see. Now, how can a landlord pre-screen a tenant?
It's a controversial topic because you end up with Human Rights Code considerations. Landlords do a terrible job of screening, and part of it, and a lot of my clients and a lot of my followers are realtors, so I want to be careful what I say, but I want to be honest as well. A lot of realtors don't do the job that the homeowner thinks they're doing in terms of due diligence when they're finding tenants. And frankly, and I get that, for the realtor, it's hardly worth the money, the half the 1 month's rent that they're splitting with the tenant's realtor, to do the job really properly. But if you don't check tenancy history and employment history and credit checks, it's almost tantamount to negligence on the landlord's part or on the realtor's part. The first video I mentioned on the 3-pack, Starting a Tenancy, deals extensively with the tenant search. You can't be in a hurry. You need to be careful about Human Rights Code considerations, but you need to search far and wide. The whole realtor paradigm of finding a tenant is broken, it's wrong, and it's dangerous, because realtors want to superimpose the paradigm they use for purchase and sale of a house into leasing a property. And that is, they want to do serial searches, irrevocable serial 48-hour searches. It's crazy. If I'm the homeowner, I want to do what's sort of akin to an offer day, if you want to call it that. I want to have 10 people come and see my house on Sunday afternoon. I want to take those 4 who are interested and then, conduct my checks and then make the decision. And by conduct the check, I don't mean take the Equifax report that the landlord's realtor has been given by the tenant's realtor and peruse the Equifax report. It was photoshopped.
Yeah.
Online, you can go to Facebook and you can buy for about $250 a full package of employment and tenancy and credit reports to give to the prospective client. You run your own credit report, you contact previous landlords, but you make sure it's the previous landlord. You contact the employer, but you check online to see if that's the employer's phone number or email address. You need to be very careful, because the only time you have some semblance of control is prior to the start of the tenancy. You need to be careful. You said, what steps can you take? What questions can you ask? The Human Rights Code has a regulation that deals with appropriate screening techniques by landlords, and it says you can do credit reports, tenancy history, employment history. You can get this information, but you have to ask for all of it. If a landlord, for instance, simply says, sorry, the house is $3,000 a month and you only make $1,200 a week, and that doesn't fit my ratio, that's contrary to the Human Rights Code. You can't use ratios. What you need to do is be careful and ask for all the information, that is tenancy history, credit history, credit report. Check online, check their social media. Go to sites like openroom.ca, where landlords for no charge can upload their own LTB decisions. And by now I bet they have 25,000 decisions. And punch in your tenant's name, Harry Fine, Fine Harry, Harold Fine.
Yeah.
You can go to canley.org, the Canadian Legal Information Site, and go to the divisional court rulings, and go to the Landlord Tenant Board rulings, although they're not complete.
Yeah.
And put the tenant's name in. It shocks me.
I don't think many people do that kind of due diligence.
But it's so easy.
It is.
And I just don't get it. And while my heart goes out to them when they're in trouble, I'm very hard on landlords generally. You can run a hobby like a business, but you can't run a business like a hobby.
Yeah.
And one of the weird things about the residential tenancy relationship is it's the only type of business I know of where the customer tends to know more about the law than the business owner. And that's perverse.
Yeah.
But it's true.
Yeah. I have seen certain contracts which state that the landlord, if the tenant does not pay their rent, the landlord can contact their employer or garnish their wages, and then they have the tenants sign those contracts prior to the lease starting. Is that valid?
Well, as you know, being a lawyer, you cannot contract out of your statutory rights or obligations, whether it's in employment context. I can't make a deal to work for less than minimum wage, to work, behind the counter. If I do sign that agreement has no force or effect. So the way it works is this. The RTA is somewhat of a complete code. The Residential Tenancies Act is somewhat of a complete code of the rights and obligations between landlords and tenants in residential tenancies in Ontario. If it's in the RTA, that RTA rule will apply, notwithstanding any waivers or agreements to the contrary. If the RTA is silent on it, then you are free to contract. So for instance, the RTA doesn't talk about smoking. So you can have a no smoking lease. The RTA doesn't talk about plugging your Tesla into the plug which the landlord is paying for electricity. So you can have a clause in the lease about the tenant shall not do this. However, the RTA does talk about rent increases. It talks about whose obligation maintenance is. It talks about not prohibiting pets, which is very difficult I'm a pet owner. Yeah. I can't imagine living without my dog, and that's why the law does not allow landlords to evict a tenant just because they have a pet. So it doesn't matter what a landlord says. I can come in and without notice to check on things. You have to leave after. One of the most amazing things is people don't recognize there's no such thing as an absolute fixed term tenancy in Ontario. So the landlord may have an agreement that says you have to leave at the end of this year, but the tenant doesn't have to leave. When the ministry brought in the standard government lease in 2018, the reason they brought it in was because there were so many terrible leases with unenforceable clauses. So they brought in this document that was meant to be now all things for all people. But the problem is when you try to draft something that's all things for all people, it really doesn't work for anybody because it's too generic. So in 2018, I decided this is not suitable. Landlords aren't protecting themselves. And fortunately, the law permits landlords to add additional clauses and terms, providing they don't contradict the RTA.
Okay.
So I looked at leases I'd been using and modifying and providing to clients for years, and I made up a schedule of about 100 clauses, and it's sort of like a dim sum menu. And it's annotated. It tells you what the clause means, and sometimes gives you choices, like 4 different ways to charge for utilities. Or if you're in a condo, take this clause and cut and paste it.
Yeah.
And the thing I sell most on my website is my landlord forms package.
Okay.
It contains about 30 forms that turn you into a more professional landlord and certainly make you appear more professional to the tenant, which is important, because just while you're evaluating them, they're evaluating you. But the cornerstone of the landlord's forms package is the lease appendix, which people adore. And when they make up good leases, taking the standard government lease and then taking clauses that fit their specific home, whether it's a triplex or whether it's a single family home or whether the landlord's sharing and it's in the basement, or whether it's an apartment building, or whether it's in a unit in a condo. Every tenancy is different.
Yeah.
And it's really a masterpiece of using my experience to try to make things that are enforceable, or at least arguably enforceable, and that protect the landlord and clarify things for everybody. And I sell a lot of them. That package is also $99. And it's really a no-brainer. Every landlord should have it.
This episode is sponsored by Kapoor Law Firm, your trusted real estate law firm serving all of Ontario. Whether you're buying, selling, or refinancing a home or business, their expert team can guide you through every step. And here's a bonus for our listeners. Subscribers to this show can receive a one-time coupon for their upcoming closing. Visit thekapoorpodcast.com to claim yours. Perfect. Now, we've seen influx of international students over the last few years. There have been a lot of issues regarding price rises, basement scams, what have you, right? What are, if there are any, protections for the international students?
Well, some of the municipalities try to create protections. I mean, you look at Brampton with their a bylaw in certain of the south central wards in Brampton, and it's a real problem. I mean, the problem is people need a place to live.
Yeah.
And there's no place to live. Landlords, and I think unscrupulously, divide their home into 10 units, 20 units. Everybody's victimized. It happens in the Indian community, happens a lot in the Chinese community. I have a huge following in the Chinese landlord community. I used to teach Chinese landlords, and I'm on Red Note and WeChat. And from time to time, you know, and I send this to people who don't want to listen, a story about this young, beautiful 19-year-old girl from, I think she was from Shenzhen in southern China, and she died in a house in Scarborough in the basement. And this is what happens, and landlords don't realize they could
But what happened in that case?
They could end up in jail. I mean, there was no fire safety, there were no smoke detectors, there was a fire, she died.
Oh.
But the municipalities are complicit because people need a place to stay. There simply aren't enough places. So what protects the student, the foreign student? Very little, because there are no options. If all they can pay is $800 a month for that shared, or $1,000 a month for that shared space, this is what they're going to get. There isn't any other space. Even though I don't take clients anymore to the LTB, I get a lot of Chinese landlords calling me and say, my daughter is in trouble, she's being victimized, the landlord tells her he's going to lock her out, throw her stuff out, and while I can't represent them, at no charge, I just feel my heart goes out to them, and I'll have a phone call with the parent and the child, and I'll talk about what the law says and what their options are, and sometimes I even perhaps dictate somewhat of a letter they might want to send, and it's very sad, and I don't know the solution. Toronto, now has a solution coming up the end of June for evictions for renovation, renovictions they call them. It's going to, I think, eliminate the N13 notice for eviction for extensive renovation in the Toronto area, because the way it doesn't mesh with the RTA, the way the bylaw overcomplicates and doesn't mesh with the RTA, it will make it almost impossible. Very few small landlords are sophisticated enough to go through the steps that the City of Toronto will make you take to get a renovation license, pay compensation, pay money to top up any additional rent they'll have to pay elsewhere before they come back, submit reports to the city. My gosh, it's a bureaucratic nightmare and empire building by the City of Toronto, but it will eliminate, they think they're solving a problem, and maybe they are, but what will happen is nobody will renovate their units.
Yeah. Now, coming back to the international students, have you heard of any other stories, like horror stories that you can...
Well, sure. I mean, I go online every day, looking at, Googling for landlord tenant issues, and I see, lots of problems with tenants just having their stuff thrown out on the lawn, or tenants who won't leave and tenants who've trashed the place. When you have 10 tenants in your basement, when you have an illegal basement apartment, even with one illegal basement apartment, you've become partners in crime with your tenants, because the tenant then holds tremendous power over you, because all they have to say is, don't hassle me or I'm going to contact the municipality. And so I have all sorts of horror stories from landlords who find themselves powerless, and they're afraid if the city comes in, fire department, property standards, health department, they'll be shut down, but they'll be fined and they'll be made to retrofit at big money. It's a systemic problem. It's not a tenant's problem. It's not the landlord's problem. It's not just the city's problem. Federal government, is in charge of immigration, and yet there's no jobs for many who come, no housing, no health care. It's a terrible mess.
Any advice that you can give to any new international student who's just come here to kind of safeguard their interest?
Absolutely. Go to the Landlord Tenant Board website and find out what your rights are. From a tenant perspective, there's lots of online tenant groups on Facebook where people are pretty knowledgeable, non-lawyers, non-paralegals, but people have gained a lot of knowledge and they share that knowledge. You've got to stand up for your rights. You've got to let the landlord know that you know what the law is. You may not want to let them know that before you move in, because otherwise landlords may be very selective. But tenants need to go and look to the LTB website. There's so much information there. There's so many brochures on starting a tenancy, ending a tenancy. There's no excuse for not knowing your rights as a tenant.
Go to the landlord by themselves, approach them themselves, or hire a professional like a realtor to look something for them?
In order to find a place?
Yes.
Realtors are good for finding places because they have the MLS listings and they'll have a wide variety of places for you. I believe in using realtors from the tenant's perspective to find a place. I'm not as big a fan of landlords using realtors because they're not doing their due diligence. And that's why I provide the information that I do in the Landlords Essentials 3-pack and the Starting a Tenancy webinar, because landlords need more information. For tenants, absolutely. Use a realtor, use social media, but be careful. Go and see the place. Don't rely on pictures. There's also scams where pictures of units that are being rented are not even owned by the person posting the ad. They're owned by somebody in Europe, and and those happen. Another thing that international students do, if they have the money, is they're paying full years up front.
Okay.
It's a big issue. The Landlord Tenant Board, if the tenant filed an application, could get it all back. Most of the time they don't, but the landlord is not allowed to charge a deposit of greater than 1 month's rent to be used for the last month of the tenancy, not the term. Some landlords charge it anyways, and then if something happens, if the tenant moves out early, if the tenant, because in a world of Donald Trumps, the tenant can't come into the country, and now a whole year's rent is paid. Tenant says, I want it back. Now the landlord's in a very strong position because they've got your money.
Yeah.
And legally, they can't just keep your 12 months rent. But, you're in Guangzhou, and how do you get your money back? So it's you need to be very careful about paying upfront rent.
That's interesting information. Obviously, at this point of time, the landlord-tenant board matters. The hearings are taking over 200 days, right? Why do you think there's such a backlog?
Well, certainly COVID, it closed from, March 20th till August. It closed for 5 months. So they've never got through that backlog. They're slowly chipping away at it in terms of number of hearings held.
Yeah.
And they've created all sorts of processes to try to do it faster. Some of those interfere with fundamental natural justice, so there's a balance there. But on the other hand, there's a tremendous push adding applications. Why is the Landlord Tenant Board the busiest tribunal in the country? The democratization of information through the internet, online groups like Facebook groups for tenants, unemployment that ultimately creates things at the Landlord Tenant Board, the real estate situation in Ontario, how for 20 years, rents went up like this, but rent inflation went up like this, but increases were like this. And so that creates some pressure for landlords who want to evict for those types of uses. The Landlord Tenant Board, I find, takes an overly procedural approach to hearings. I remember back in 1998 when the Tenant Protection Act was being introduced and the Ontario Rental Housing Tribunal was going to open up on June 18th, 1998. And it was going to be faster, quicker, cheaper, much easier for small landlords. And maybe it was on day one, but none of that is true today. In effect, the procedural requirements have almost reversed themselves, where it's easier to go to court, where a judge knows how to deal with unrepresented parties, than it is to go to the LTB, where they're so frightened of one divisional court decision. As an adjudicator, I had a great mentor. His name was Jeff Rogers, lawyer, and he went on to FISCO after that, the Financial Services Commission. And Jeff taught me that you are not going to get overturned on review or appeal if you do the right thing and explain why you did it. So I was somewhat courageous and went out on limbs to do the right thing. I took all the tools I had to do the right thing. Mm-hmm. They're so pressured by time today. It's so much easier to say, I found a little mistake, application dismissed. Remember, when an application is dismissed, that creates a backlog because the application gets refiled.
Yes. Is there a way to fix this?
Well, without statutory changes, without changes to the law, no. The law keeps getting more and more difficult. And for instance, I look at the BC, British Columbia Residential Tenancies Act. There's a provision in the BC RTA that has a deeming provision for defective notice. So for instance, if a notice is 3 days short, the notice is deemed to be correct on this day.
Okay.
So they can look at any notices, which are the greatest reason for applications being dismissed, and they can have it deemed to be correct even though it's not correct.
So that's not the case in Ontario, right?
If only it were.
Yeah.
It needs adjudicators to have great representation from paralegals and lawyers. And when small landlords go on their own, they don't do themselves any favors. I get it. I know it's expensive. I know they may not have the extra $3,000 to hire a paralegal, but they're just not doing themselves any favors because it just makes it so easy when they not only don't know the law, but they don't know their procedural rights, the administrative law things that would help a paralegal understand their rights before a court or tribunal. And that's really why I started doing the videos. I mean, sure, it was part of the business model when I started slowing down, but I create a middle ground, and it's a wonderful middle ground because the videos are accurate, they're up to date, they're comprehensive, they're easily explained, they're backed up by documents. So rather than do it yourself or pay thousands, landlords have an opportunity to try to do it on their own. And they need that because to go there just listening to your friends, listening to your realtor, there's so much misinformation out there. I just did another short on the Chinese media sites, and it was a 2-minute thing, Everything You Know Is Wrong. And in the world of landlord-tenant law, what people know is what somebody taught them, which somebody else taught them, which years ago somebody else taught them.
So here's
everything they know is wrong. Yeah. The law is always changing. The interpretation is changing.
So do all the jurisdictions in Ontario have similar wait times, or some jurisdictions are better than the others?
There's no longer jurisdictions. I mean, they exist in law, but everything is virtual.
Okay.
So now people often, you see them asking a question, I need a paralegal in Windsor. No, you don't. It doesn't matter where the paralegal is because everything is done
everything
virtually.
is online?
Yeah.
Okay.
So there's
So any paralegal in Ontario can represent any matter in Ontario?
Absolutely.
Okay.
Yeah, what makes landlord-tenant law interesting as opposed to, and more difficult when you have delays, as opposed to something at the Superior Court, small claims court, is usually when you get sued at those other courts, the damages have crystallized. The damages are fixed. I'm suing you for that $500,000. With residential tenancy law, as the rent continues to be unpaid and the maximum monetary jurisdiction of the board is only $35,000, there's a huge number of judgments at the board that are capped at $35,000 because of the statutory limit. Yet the tenant, by the time they finally get their order, they owe $75,000. You probably are aware that in September, I think September 10th, the jurisdiction of the small claims court goes to $50,000. That will change the jurisdiction of the LTB to $50,000. Great thing.
Yeah.
But still, you lose, and it's over. Landlords come to me and say, Harry, I was trying to get my house back for my family to move in. My family just moved. I've been here by myself for 3 years. My family has finally come. They've been granted immigration status. I filed the application. I went to the board. I'm going to get my house back. I lost. Can I file again?
Yeah.
No, you can't file again. The matter's been determined. You can't afford to lose.
So, Harry, Ontario's rent is capped at 2.5%. Everything has gone up. The interest rate has gone up as well. Is it fair on the landlords? What are your thoughts?
It certainly is not fair. I remember in 2007 when the law was changed to depoliticize the guideline and have it mathematically calculated. It was a great day, and it was good for the government, and that it wasn't a political approach. And then in 2012, the government at the time said, and that was the Liberal government, said, whatever the increase is, because it was 3.1% the year before, and the tenants screamed, whatever the increase is based on the math, it's no more than 2.5%. So right there, it was crazy. Condos, obviously Toronto and the whole GTA is now just ripe with condos everywhere.
Yeah.
And one of the problems with rent and condos is that when you have increases in maintenance fees or you have special assessments, those are all non-recoverable through the special application called an above guideline increase. So if I owned a house and I put a new furnace and a new roof, etc., I could go to a hearing and get permission to raise the rent more than the guideline based on those capital expenditures. Also based on increases that were extraordinary for realty taxes and extraordinary increases for utilities. Those three things. In 2017, when Kathleen Wynne changed some rules about the RTA, one of the things she did is she wiped out the ability to file an above guideline increase for utilities. And so he was asked, why? How could you, what if the landlord's utilities have doubled? She said, well, the landlord should be buying energy efficient appliances. But what if the landlord already had energy efficient appliances and his utility cost doubled? So look at the things they've done. I mean, they've capped the guideline at 2.5. They took away the above guideline application for utilities. They don't allow in condos, which is the new rentals, frankly. Condos are the new rentals. They don't allow special assessments or increases in management fees, in common area expenses to be used as part of above guideline applications. It's so unfair. And the basket of goods that they use in the CPI isn't necessarily what types of expenses landlords are experiencing. So the whole thing is out of whack. Rent control is a double-edged sword. I mean, it provides stability for those tenants who would otherwise be trapped and couldn't afford to stay there. It also traps them in the unit they're in, because if they moved out, they know their rent is going to be $1,000 a month more. So they can't really move, even if their jobs moved or a relationship changed. For landlord, it's a terrible thing. I mean, you now, with the N13s for extensive renovation really being out the window in Toronto, so you can't fix the place up. You can't raise the rent when your costs go up. The place starts getting worse and worse because you don't have the money to put the money into fixing the place. And you're really in a bind. Half the condos in Toronto right now that are rented are cash flow negative. Condominium ownership right now in terms of rentals are the worst. And rent control is the cause of that. Rent control stopped landlords from building buildings. Mm-hmm. They built condos instead, because with condos you get your cash out and you run to the next project. So rent control is quite an issue, and
this needs
I don't
to
know
be
what's
addressed.
right.
Yeah. A recent case in Brampton, there was, a tenant owed over $25,000 to the landlord, took over 1 year to evict the property. What do you think in such situations? How can the landlord be protected?
I think I saw that case in the paper, although every day in the paper or online, I see a similar case. Sometimes it's $75,000, sometimes it's $25,000. It's easy to say on one hand, and a lot of people will, that the landlord got what they deserved because they turned the place into a unlicensed illegal rooming house and they shouldn't be profiting off that. And there's an argument to be made for that. On the other hand, the RTA exists for the use of landlords, and it should be faster. And it's not faster because there are so many ways for a tenant to manufacture delays, to get adjournments, to file reviews. One of the things that encourages the loser, and I'm talking about tenants in this case, at an LTB hearing to file reviews and appeals is it's almost risk-free. The LTB has its own internal process to fix their own errors. It's called an administrative review or an internal review. That's different from the appeals at the courts. And the internal review process costs $53 for a tenant to file.
So what happens in that?
And what's the risk? So you file a review. And it's sort of a two-step process. It's a written request for a review hearing. And an adjudicator sits in their office and decides if the written request warrants a hearing to determine if there was a serious error. So the written request looks for the potential for a serious error. If there is, they send it to a hearing to determine if there was a serious error. And then if there was, they will hear the matter fresh. It doesn't matter what you put in the request for review, because there's no penalties for lying. I remember a case I had, either Guelph or Kitchener at the tribunal, and I got there one morning with my client. It was 10 o'clock. The adjudicator was there. And right at the beginning of the hearing, he said, "Mr. Fine, just so you know, we're going to have to stand your matter down to another day." I said, "Why?" He says, "The tenant can't be here." I said, "Why?" He said, "The tenant suffered a stroke this morning." We knew this was an acrimonious relationship. We knew this was a tenant who was playing all sorts of tricks. So a month later, there was another hearing, and the tenant didn't appear, but this time he didn't have a stroke, and we got a judgment. And then just before the judgment was ready to be filed with the sheriff, he filed a request for a review, another stroke.
Okay.
There was no stroke. There was never a stroke.
So he was lying.
But how can the adjudicator not send it to a hearing if it says I had a stroke and was in the hospital? The adjudicator has to send it to a hearing. So 40 days later, you have a review hearing. The tenant doesn't show. Obviously, the review request is dismissed. And then sometimes the board will say, "I'm going to order costs of $250 against him." well, so what?
Yeah.
I mean, it's been 6 months. So the adjudicator orders a $250 cost award, and the tenant files a reviewer appeal saying he wasn't there in person to speak to the issue of costs. And another review is granted. I mean, and the weird thing is, and any adjudicators who are watching your podcast won't like me saying this, but when I read the divisional court appeals by tenants, which are most often dismissed, denied, divisional court is so common sense and takes such a rational, pragmatic view on the appeals that come before it. The LTB does not. In my mind as a paralegal, and I teach aspiring paralegals, that when you go to the board representing a client, it's just a setup for divisional court. Because if you don't get it on the record, you're in trouble if this matter gets appealed. The LTB adjudicators will misapply their discretion too often, and frankly, the divisional court is sick and tired of 25% of the appeals that come to divisional court are from landlord tenant board decisions. Yeah. And of those tenant decisions, 80% are dismissed. And what did it cost the tenant to file the appeal to divisional court? Like $280. So when a landlord takes, like the case in Brampton, it's easy to be owed $100,000. It's easy to have your basement trashed. Many years ago, there was an attempt by a government here, I think a provincial government, to introduce SCAN legislation. Forget the bill number. Safer Communities and Neighborhoods. It's typical in some jurisdictions. It's legislation that allows obvious malfeasance and bad behavior to be dealt with without judicial oversight. In other words, let's get the drug dealer out of the house, forget the LTB, this is obviously a crack house, and then let the courts deal with it later. The left argued against SCAN legislation, saying it was unconstitutional, interfered with rights, and it does. Everything's a balance of rights.
Yeah.
And so it never happened. But we need a way for enforcement of bad behavior that doesn't take all that time because, as I said earlier, your damages are not crystallized, whether that's physical damage for the property or rent that you're owed, or the fact that your child lives upstairs and is being terrorized by the drug activity in the basement. Mm-hmm. Your child's 8 years old. I've had cases. I remember one of the first cases I had, immigrant parents, tenants in the basement, 8-year-old daughter. The parents one of them had to switch shifts at work so somebody could always be home because people were yelling downstairs, screaming. Smoke was coming from downstairs, starting fires. It was a terrible mental health issue.
Yeah, that's scary.
We are also proud to be sponsored by Kapoor Vastrale with locations in Mississauga, Ontario, Surrey, British Columbia, and Fremont, California. For the finest selection of ethnic Indian clothing, visit your nearest store and explore their beautiful collection. And just for our subscribers, you can get a one-time discount coupon by visiting thekapoorpodcast.com and filling out the form.
I also want to talk a little about tenants. What are some of the mistakes that the tenants can make during the eviction process?
Well, tenants thinking that, and this happens a lot with international students because one, language is a barrier, and two, governments in some countries, let's take China, they're more authoritarian. People don't tend to want to get involved in the judicial system, don't want to get involved in any sort of administrative procedure. So when a landlord says to a student, you'll have to leave, they just leave. When a landlord serves them with an N12, a notice to terminate the tenancy because their family wants to move in, and when a tenant retains me or calls me or I'm casually advising them, and they say, what should I do? What should I do? And the answer I give the tenant is nothing. You just don't move.
Okay.
And don't even tell the landlord why. Just say, I'm not moving. Or say there's a process in Ontario. Figure out what the process is, landlord, and follow it. Because, and I say this with some confidence, 75% of N12 notices served for family or purchase or move-in are not made in good faith.
75%.
75%.
That's a big number.
So let it go to the board. And of course, if it goes to the board, the landlord has no interest in that because at that point they're going to lose. One of the things that's most problematic with the good faith ones, the ones that are not for landlord's use but for purchasers' intended use or purchasers' family use, is that not only does the law make it difficult, but the timing makes it difficult. You can only serve your tenant in that situation, the N12 notice, once you have a signed agreement of purchase and sale with conditions waived.
Firm agreement of purchase and sale.
Yeah.
Okay.
Not a completed agreement, but an unconditional agreement. So today, you're buying my house, we've signed the APS, the conditions are off, and the closing date is 60 days away or 90 days away. Now I'm the landlord. I can serve the tenant with the N12. Tenant says, I'm not leaving.
So what's the timeline from when the N12 is served?
Well, that's the problem, because you're not going to get the eviction, and by that I include the sheriff enforcement, for 8 months. So what I say to people, and a lot of people don't like it, a lot of real estate lawyers don't like it, a lot of realtors don't like it, you cannot sell a tenanted property that unless the purchaser is really going to move in and the tenant is willing to move out on their own, or unless the tenant is just naive and moved. You cannot sell a tenanted property. And as you know, and this is your expertise, if I'm guaranteeing vacant possession, and then, my gosh, the tenant's not gone on closing day, so the buyer refuses to close, the buyer sues for his deposit back, the buyer purchases another house in a rising market, the buyer pays $200,000 more for the new house, the buyer sues the landlord, owner, seller for the $200 plus the return of the deposit plus their legal costs. And do you know those don't even go to merit hearings? Those are decided on summary judgments. The law is so clear. They will get that on a summary judgment because nobody told the seller landlord that he can't guarantee vacant possession with a tenant in the basement. So what is the solution, they say? There isn't one.
Yeah, it's messy. It's quite messy.
Well, a tenant knows how to do it. They say, sure, I'll leave. And $75,000 is the amount.
Yeah, I've seen that. I've seen that happen, and it's quite common these days.
Oh, terrible.
Any other instances of unreasonable landlords that you've come across?
Certainly, there's loads of bad landlords. I mean, I'm not a landlord side guy or a tenant side guy. I used to be when I was busy working. You really can only work one side of the street, and landlords were my bread and butter. But then when I sort of semi-retired and took cases, I probably represented more tenants.
Okay.
Because landlords do some awful things. They don't repair and maintain their units. They don't even do a pest control inspection between tenancies. They don't do fire. They don't comply with fire code issues. They overcrowd. They have illegal basement apartments. They enter without proper notice. They harass and sometimes sexually harass tenants. There are some awful landlords out there that don't realize that it's a business. And it's no different than if you were Minto or Realstar or Dell or any of the big residential landlords. As a small landlord renting out your basement or a triplex, your obligations are no different than Minto's. So I say to small landlords sometimes, do you ever see the tenants in a Minto high-rise shoveling the snow or cutting the grass? I say, well, no, because it's your responsibility. And if the fridge breaks, and a huge number of small landlords, I don't want to guess the percent, don't pay interest on the last month's rent deposit, which they retain. So what happens? You don't pay 2.5% on $2,000, so you don't pay the $50 annually. Or next year it's a little more because the deposit would also keep increasing, or the rent would be increasing. You could top up the deposit with the rent, but that's another story. So you don't pay interest on the last month's rent deposit, and the tenant knows, and the tenant's angry because the tenant knows more than you do about landlord-tenant law. But the tenant has no way to get back at you except break your fridge and then say, my fridge is broken. Or shake some water pipes until there's a small leak. and then have some damage in the basement, and then tell the landlord there was $100,000 of their stuff ruined in the basement because you didn't pay the $50 interest on the rent deposit. It's crazy to start a war.
Yeah.
For landlords, I would say, remember that you are not the lord of the land. Even the term is misleading. It's the contractual and statutory relationship of equals. And if you don't have a good tenancy agreement, you don't have that right. And if the tenant has a right in law, either through the lease or the statute, then that's not a right you can just decide that you don't want to give them or change it. It's sort of like an easement. I mean, you're giving them the place, without title, but for their enjoyment.
For sure.
And landlords don't get it. Small landlords don't get it.
Okay. We did touch base on the N12. I want to ask you if the landlords should issue the N12s themselves, draft it themselves, or should hire someone who's professional, who knows how to do it?
The serving of the N12 is easy. I mean, because the N12 itself is easy. Assuming the landlord knows, okay, month to month, the tenant pays rent the first of the month, so that means I have to count 60 days and then go to the end of the month, so that'll be July 31st. I'll double check the days. I know how to serve it. I know the landlord's name. I know the tenant's name, termination date. Good. But it doesn't end there, because before they start the legal proceeding, and this is also true of N4 notices for rent, I say contact the paralegal before you even write a letter, because everything you need will be scrutinized. Everything you write, I should say, or say will be scrutinized. I tell clients that just everything you write, just imagine it's going to be read by the judge. Mm-hmm. And so if you're going to evict somebody because your family wants to move in, you need to talk about the process with somebody. You need to find out, oh my goodness, the house is owned corporately. I didn't realize that. I can't move my family in. Or they're still in lease term. I didn't know that. I can't move my family in. Or there's mental health issues in the tenant. This could be a complicated move in. So before you serve any notice of termination, the N4, 5, 6, 7, 8, 12, 13, retain somebody, or I have a middle ground. If you purchase my 2-hour-long module on evictions for N12s and N13s, you will be very, very prepared to do it yourself. And if you want to do that, it's not as good as having a good paralegal, but it's damn good. And you have a good chance of being successful in doing things right. Don't start the process. How many times have I seen N4s be served? The most common notice is a notice for rent arrears. And then they often, when the 14 days after service has expired, they retain the paralegal. The paralegal gets the N4, or sometimes it's worse, the landlord files the application, and then they retain the paralegal at the hearing 6 months later.
Yeah.
And then it turns out the N4 has a mathematical error. Done. Finished. Or it's 13 days, not 14. Done. Or it's 14 days, but it was served by mail, which is deemed to add 5 days, so it's done. And you start all over again.
My God.
I would tell my clients when I was busy practicing who gave me N4s and said, could you file the application, please? I would say, I want a rent ledger from you. It can be handwritten if you want, going back to the last zero balance. And I'll bet you I have to redo your N4. But if I do, that's not a big issue. It's 14 days.
Yeah.
It's not 6 months.
Okay. Now, there have been a lot of short-term rentals, Airbnbs that are in the picture right now, right? So how does it change the landlord-tenant dynamics in such scenarios?
Short-term rentals are complicated, partly because different cities have their own bylaws in some cases. You look at Toronto's, for instance, where you have to have a bylaw license number and has to be your principal residence and only so many days a year. I've got to figure that 2/3 of the Airbnbs in the city of Toronto are illegal, but the city doesn't have the enforcement to deal with it. It certainly affects the landlord-tenant landscape because there are fewer rental units for traditional long-term tenancies. So it's a bad thing, I think, from a public policy decision. I mean, I love Airbnbs if I go to Rome.
Yeah.
I hate Airbnbs in Toronto. They're not good for the neighborhood. They're not good for the building, certainly.
Not many buildings allow Airbnbs.
So they may not allow it, but there's so many landlords trying to do that.
Okay.
If you go online and look up the history of the Iceboat Terrace downtown Toronto, you should go out and look up the news stories. It's remarkable what can happen to a building and the value that's been eliminated from people who honestly owned it to live there, or as an investment, their investment's now in half. But in terms of how it interacts with the RTA and landlord tenant stuff, people get confused because they think, okay, I'm in Toronto, the city says 28 days, so it's exempt from the RTA too if it's 28 days. Well, the RTA doesn't determine and define what a short-term rental is the same way the city of Toronto does. The RTA simply says it's a place that's like a hotel, a bed and breakfast, stuff like that, or it's intended for the traveling vacationing public, or for short-term accommodation. I mean, it looks at it differently than the strict rules. It looks at the actual intent. What did the parties intend it to be? Did it tend to be for a vacationing public, or did they intend it to be somebody who's living there and then it's going to get renewed and then it's going to get renewed again? But for the landlord, it gets tricky because, and I've seen it several times, they rent out on Airbnb, but they decide to bypass the Airbnb platform to save the commissions.
Oh, really?
So they advertise themselves for short-term rentals, and the 30 days is up, and they did say it was for 30 days or 28 days. And they contact the tenant and say, I have my cleaner coming in today at 4 o'clock. You need to be out by 4 o'clock. And I've seen this. And the woman wrote back and said, remember that the other day you came in and I was in the shower. I can't believe you came in when I was in the shower. But, we talked a bit and you said I could stay here long term and my rent was $1,200 a month. Landlord says, what are you talking about? You came in, it was Thursday, and I put my bathrobe on and we sat on the couch and we agreed I could stay here and convert this to a residential tenancy at $1,200 a month. I'm not leaving. So what do? You go to the police say RTA issue, landlord tenant issue. Now you wait 6 months for a person who stopped paying any daily occupancy fees. You wait 6 months for a hearing, and maybe it is the adjudicator has to decide, is this, a tenancy governed by the RTA? The Landlord Tenant Board under the RTA and under the rules of practice does not have a quickie motion procedure. There are some things that should be decided by an emergency motion. Does the act apply? Because if I can get a judgment from the LTB in 2 weeks that say the act does not apply, I can take that to the police, and the police can say, ma'am, you're trespassing.
Yeah.
But the fact that there is no emergency motion process when so many issues are ongoing, they aren't crystallized, is a huge conceptual problem in how things should work. Boy, I'd love to rewrite the whole system.
Now, dynamics are changing with AI and technological advancements. Do you think things can improve? The timelines can change? What are your thoughts?
I don't know. I mean, the courts and adjudication are so often, assume that the parties have pure hearts, but often they don't. And if people just want to out and out mislead and commit fraud and lie, because people fight like heck. Landlords and tenants, historically, they're at odds. And adjudication is required. I mean, the courts, tell you that certain types of rights that are of great interest and have a great effect on your life need to be decided by adjudicators. And that takes resources and that takes time. And I only see the volume increasing. There are some systems, you see them in some cities, I think like New York City, all the parking stuff is done online. Mm-hmm. And it's done, with AI. And they have systems where the parties can mediate through AI and make offers, et cetera. The problem increases when there's more and more poverty. And Toronto is experiencing more and more poverty. People that may make as much as they used to, but inflation's gone crazy. or people who've lost their jobs and now are suffering real poverty. And when you ain't got, Bob Dylan said, when you ain't got nothing, you got nothing to lose. So for tenants who are going to be homeless, they are going to use every possible avenue at their disposal to delay. And there are so many ways to delay, not all as extreme as saying I've had a stroke that morning and I couldn't appear. So I don't know how any sort of online AI mediation system, if I simply say no, because I know you can't enforce against me, I'm judgment proof, then what's the incentive for me to move the matter along? And you see a lot of that. You see a lot of that in the social housing world, the nonprofit housing world, but you see that in the world of people who are in the workforce and retail jobs and just can't pay the rent, or jobs, without skills, without experience, without education. How they live in Toronto, I don't know. Costs are out of control.
Right. That's great, Harry. We're just about to conclude. One last piece of advice that you want to give to the landlords and to the tenants.
To the landlords, remember that it's a business. And if you don't want to run it like a business, then you shouldn't be in the business. It's not a passive investment. It's an investment like any other, but like any other, Tesla stock went down 14% yesterday. And you could lose everything on your rental. For the tenants, I would say, know your rights. Let the landlord figure it out. Don't figure it out for them. You have tremendous protections here in Ontario. But on the other hand, it's a two-way street. Take care of the unit. Make sure that if the rules say no smoking, or if the rules say you can't use the driveway for more than one car, then follow those rules. Because once people don't respect the rules that they've agreed to, it ends up very messy. And sometimes very messy will result in your eviction. Sometimes it gets pushed too far and tenants push back, but don't realize they've overplayed their hand and they end up being evicted, which nobody wants.
Perfect. This has been great, Harry. Thank you so much for being here.
It was a pleasure to be here.
This episode of the Kapoor podcast was proudly sponsored by Kapoor Law Firm and Kapoor Australia. If you are enjoying the show and want a one-time discount code, head over to our website, thekapoorpodcast.com, and fill out the form to receive your subscriber-only discount code. Whether you're looking for legal expertise or premium Indian ethnic wear, our sponsors have you covered. One more request to all of you, please do subscribe to the show and leave a comment to let us know what you think and how we can improve. We'd love to hear from you. Thanks for watching and see you in the next episode.